All right, thank you very much. Thanks for having me here in Lincoln. This is my first time to Lincoln. I got here last night and was exploring the city. I went to a yoga class this morning. I sort of expected Lincoln to be a big football town, but it actually seems kind of like hipster. I don't know, maybe it's just the parts I'm checking out, but I'm enjoying it so far. I'm going to talk to you a little bit today about the role of the United States in water litigation, a lot of which takes place in the Supreme Court. I'm going to take you through how a Supreme Court case on water typically develops, and I'm going to talk probably a little bit about each of the original actions that's currently pending, and I'll try to focus as much as I can on Kansas versus Nebraska, which was decided just a few weeks ago, which I think a lot of people in here are probably quite interested in. I don't know how many people in here are lawyers. I assume many of you are not. There may even be some law students. So I'm going to do a little bit of basic PowerPoint slides at the beginning just about the original jurisdiction of the Supreme Court. The United States Supreme Court has a really unique role to play when it comes to water disputes because a lot of times they're interstate in nature. So when there's an interstate river, each state has a sovereign right to a portion of the water. And the states will oftentimes decide amongst themselves how much each state gets, and they divide it up through an interstate compact that then gets approved by Congress and becomes a federal law. Sometimes if the states can't agree, they will go to the Supreme Court and ask for an equitable apportionment of the water. And the Supreme Court then takes a look at the river basin and divides up the water equitably among the states that are involved. When problems arise under those agreements, whether it be an interstate compact or an equitable apportionment decree, the lawsuits are typically one state versus another state. And those suits have to be filed directly in the United States Supreme Court. So I'll just give you a couple of slides on the jurisdiction of the Supreme Court. Article 3 of the Constitution sets out all of the things that the federal courts in the United States have jurisdiction over. Usually it's things arising under the laws of the United States, federal statutes, the United States Constitution. Some of them have to do with who the parties are. So if an ambassador is a party, if a state is a party, the federal court has jurisdiction over those things. Then Article 3, Section 2 takes it a little bit further and takes out a small section of those cases, ones affecting ambassadors, public ministers and councils, and those in which a state is a party. The Supreme Court has original jurisdiction. And what that means is that you can file your case directly in the Supreme Court. It is not necessarily true that the Supreme Court has exclusive jurisdiction over suits between states, just under the United States Constitution. But Congress has made that so. So Congress passed a law, 28 U.S.C. 1251A, saying the Supreme Court has original and exclusive jurisdiction of all controversies between two or more states. So you don't really have a choice when it's a state between a state. The only place that you can file your lawsuit is in the United States Supreme Court. There are a few weird exceptions to that, and one that I'll just mention really quickly is in a case called Tarrant versus Herman, I guess is the chairman of the Oklahoma Water Resources Board, a case that was pending before the Supreme Court. The states weren't parties in that case. It was filed in a federal district court by a water district in Texas, and then it made its way up to the Supreme Court through the certiorari process. But we noticed when we were reading the Red River Compact that was at issue in that case, that it has a provision that says, even when the states are parties, you can file your case in a federal district court. And we thought, how can that be true? Because 28 U.S.C. 1251A says the Supreme Court has exclusive jurisdiction over suits between states. But then we thought, well, the Red River Compact is also a statute of the United States. And so if you have a dispute under the Red River Compact, apparently the United States does not have exclusive jurisdiction over those cases. It's just kind of a random thing. Because these cases can be filed in the Supreme Court of the United States, or must be filed in most cases, that's where my office comes into the picture. The Department of Justice is divided up mostly by subject matter. We have a civil division, a criminal division, tax division, environment and natural resources, civil rights. People are basically divided by subject matter. And that is how most cases are handled. So if there's a criminal case coming up, a U.S. Attorney's Office will handle it. It'll come up through the Criminal Appellate Division when it goes into the appellate courts. But then no matter what the subject matter is, when it gets to the United States Supreme Court, we have an office, the Office of the Solicitor General, that conducts all Supreme Court litigation on behalf of the United States. Now, except for the deputies that work in the office, and there are 21 lawyers in my office, there's the Solicitor General himself. He's a political appointee, Don Verrilli. He has 4 deputies, one of whom is a political appointee, and the other 3 are career deputies that have worked in the Office of the Solicitor General, some for like almost 40 years. And then there's 16 assistants, which is my job, and we divide the cases amongst ourselves. So anytime there's a case in the United States Supreme Court, no matter the subject matter, these are the 21 lawyers who are dealing with it, handling the briefing, and arguing the case in the United States Supreme Court. Now, we are all generalists except for the deputies, as I was saying, so I do not know probably as much as most people in this room about water law. I probably know the least of most of the people sitting in this room. My knowledge of water law is basically limited to the cases that have been assigned to me that I have studied and presented briefs and made arguments in the Supreme Court. But we don't just do it by ourselves. When a case goes to the Supreme Court, we don't say, okay, we're handling it now. That would be sort of silly because we have a lot of really knowledgeable lawyers in the Department of Justice, lawyers in the agencies that are our clients, and non-lawyers in the agencies that are our clients that know these cases forward and backward and help us to prepare. We're the experts in getting a case and shepherding it through the Supreme Court, but we rely on all of the other attorneys and people throughout the Department of Justice and the federal government to teach us and be the experts on the subject matter. Sometimes you can develop a specialty, as I have with original actions, and the way that that happens is pretty simple. When I started in the office back in 2010, I've been there almost 5 years. Kansas had just filed a lawsuit against Nebraska in the United States Supreme Court asking for permission to file a complaint for violations of the Republican River Compact. And I had just started in the office at that time. And the guy who usually did original cases had just said he was about to leave the office, he was going to go into private practice and cash in. And so when the Solicitor General was looking to assign the case, he said, Ann doesn't have anything to do, we're going to give it to her. And so I was assigned to write the invitation brief in Kansas versus Nebraska, and then the next time an original case came in, he said, oh, Ann's the one that does original cases, this case is going to go to her. So that is often how subject matter specialties develop in the Office of the Solicitor General. You can say that you have specific things that you're interested in, but we all do a little bit of everything, and we don't get to choose our cases. They're assigned to us. So for example, this year in October, I argued Kansas versus Nebraska. In November, I argued a case about local government regulation of cell phone towers. And last month, I argued a case about the felon in possession of firearms statute. So we do a little bit of everything, and I just happen to be the person who gets to do the original cases, which is actually quite fun. A lot of people in the office think they don't really know what's going on in the original cases. They're like, you're doing things before a special master. All these filings are always coming in. But I'll tell you as we go through some of the cases that I've worked on about some of the cool things that happen in original cases that make them an interesting part of the job. All right, so let's talk a little bit about how the United States becomes involved in the first place. The basic way that the United States becomes involved in original cases is the Supreme Court invites us to file a brief. Usually, if you have one state suing another, well, not usually, this always happens, the first state will file a motion for leave to file a complaint in the Supreme Court. The state or states that are named as the defendant can respond to it and give reasons why the case is not worthy of Supreme Court review. And then the Supreme Court, I'd say 9 times out of 10, but it's higher than that. It may not be 10 times out of 10, but they'll ask the United States for its views. They have a couple of options. They could just grant leave to file the complaint if it's clear that it's a legitimate case and it's important and there's no other place for it to be filed. They could just grant the case without asking us for our views. They could deny it without asking for us for our views if it looks like it's something that's pretty frivolous. That doesn't really happen very often. And then the third option is you can call for the views of the Solicitor General. And it's a pretty sweet deal for the Supreme Court to be able to do that. They do it not just in original cases, but in all sorts of different federal cases. If they're on the fence about whether they want to grant certiorari in a case, one option they can do before they actually decide whether to grant or deny it is to ask the Justice Department to file a brief. And basically, what we do after that is we put a team together of all the people in the federal government that are the most knowledgeable about that topic, and we give them the briefs that have been filed in the Supreme Court. And we say, look, the Supreme Court wants our views on this issue, so tell us in a memo, is this important to us? How could this question presented or the resolution of this case affect federal government operations? And even if it's not important to us, who do you think is right? Because we have to file the brief. We don't ever get an invitation brief from the Supreme Court and decline to respond. We always file a brief, and they expect us to give them our views on the issue. A lot of the things that we consider or that the agencies that we're working with will consider, especially in water cases, are, do we have federal projects on this river operated either by the Corps of Engineers or the Bureau of Reclamation that are going to be affected by the outcome of this case and the resolution of the question presented? Sometimes we do, sometimes we don't. Usually we have projects on the river. Sometimes they won't be affected by the question presented, and sometimes they will be very, very deeply affected by the question presented. And sometimes we may not have a view on or really an interest in the way that the compact is interpreted, but the agencies can see some sort of more general principle of law that could develop out of the case that they're very concerned about. And one example that I'll talk about is this Tarrant case that I was talking about earlier. So in Tarrant, we had a Texas water district that actually sued in a federal district court, the Oklahoma Water Resources Board. They had asked for a permit to take water out of Oklahoma to satisfy their allocation of water under the Red River Compact. And there was this section of the Red River Compact that took one particular subbasin of water and said, all 4 of the states that are involved have equal rights to this water, and nobody can take more than 25%. And so Texas said, well, we can't get our 25% from within Texas. So their plan was they wanted to run a pipe into Oklahoma and take water from that particular subbasin that was equally divided in Oklahoma. When we asked our agencies to look at it, we sort of were like, okay, it's an interesting question. The answer doesn't really affect any of our operations. There's nothing that the United States really has at stake in this case, but we still have to come up with an answer on who we think is right, because the Supreme Court's going to expect us to do that. And so we studied it as hard as we could, and we came up with an answer that we thought, yes, if Texas cannot access its 25% from within Texas, then it shouldn't be categorically foreclosed from getting a permit to take the water out of Oklahoma. And just to show you that the Supreme Court doesn't always just do exactly what we tell them to do, the Supreme Court absolutely disagreed with that in their opinion in Tarrant, and said that no, even if Texas can't get access to its 25%, if the states had thought that it was okay to go into one another's states to take this water, they would have said so in the compact. But it's a case where we looked at it and everybody said, honestly, we have no idea what this compact means. They negotiated it. They're the ones that have been living under it. We'll look through the evidence and we'll give you our best shot, but it's not something that we really have a lot at stake in. Oftentimes, we do have a lot at stake. Kansas versus Nebraska was a case that kind of falls sort of in the middle, where yes, we have federal projects on the river, yes, we care about what happens to them, but the questions in that case about how damages are calculated, it wasn't really of primary concern to the United States, but you could see the more we looked at it that we did have a view and have things that the United States cared about that would shape our view about what we would say on those topics. So after we sort of put together a preliminary view of what we think, the United States will invite the parties in to talk to us. And that's always a fun aspect of working on these invitation briefs for the United States. They say that when you argue a case in front of the Supreme Court, the argument doesn't really have much of an effect, or in very few cases does it have an effect on the outcome of the case, that normally the justices, after they read the briefs, pretty much have the case decided, and the argument, it's just there to like flesh out some issues, but it's not really going to have an impact on whether they affirm or reverse. Sometimes it might. That's why Justice Thomas doesn't ask questions, he says, because he thinks the oral argument is the most pointless part of the case. It is the complete opposite in the meetings that we have during the invitation brief stage of a CVSG, a call for the views of the Solicitor General. We put together what we think is our best ideas based on reading the briefs, and then we call the parties in and we meet with each side for an hour, and we basically ask them questions about their position, and we let them state their best case for why this case should go forward, shouldn't go forward, why we should take their position instead of the other state's position. And we ask questions, and we have all our subject matter experts in the rooms, and we really use those meetings to flesh out what our position is going to be. And sometimes after the meetings we think, well, going in we thought this, but now they've really changed our opinion, and we think this case shouldn't go forward, or we think we should take this opinion, etc. So we use those meetings to really refine our position. Whoops. And then we make a recommendation to the Supreme Court. Sometimes they agree with us. I mean, we usually say in a given case that's not an original case, our answer usually, I think somebody did a study, and it's like 8 times out of 10 we say, no, don't take this case. It's an important question, but this is a bad case to decide the issue in, and then they usually grant them anyway. But at least we've warned them about some of the pitfalls that could come, and I think they use it sort of as a vetting process. In original cases, we say yes more often just because of the standards that you apply. The Supreme Court doesn't have to take every original case that comes before it. The court has said that its exercise of original jurisdiction is obligatory only in appropriate cases. And so you could have a dispute that's going on between 2 states that the Supreme Court just decides it's not going to hear. But the 2 things that it looks at are the seriousness and the dignity of the claim and the availability of an alternative forum. And so when we're writing our invitation briefs, that's usually what the framework is for them. Is this dispute serious, and is there some other way that the parties could get a solution to this problem? On the second point, the availability of an alternative forum, in an original case, usually the answer is no, because the Supreme Court has exclusive jurisdiction over your dispute. Sometimes it could be the case that, like, you had an arbitration provision in your compact that you failed to invoke before you came to the Supreme Court, or maybe there's some sort of other, you could have gone to the Compact Commission, and so you should do that first before you come to the Supreme Court. But I have certainly not seen a state that skipped over some obvious step that it could have used before coming to the Supreme Court. Usually the states are at pretty much of a deadlock when they invoke this option. And normally when we look at these cases, I think states in general take the jurisdiction of the Supreme Court, the original jurisdiction, quite seriously, and wouldn't necessarily file a case if it was frivolous. I'm not saying that that always happens, but I want to point out one very interesting thing that the Supreme Court recently did on this topic of the seriousness and dignity of the claim. There was an order issued, I think on the same day that Kansas versus Nebraska's decision came out, in an original case called Montana versus Wyoming. Now, I haven't been working on that case. It's been before a special master for a long time, so I don't really know the details of that case. But what the Supreme Court said, the special master in that case wrote up an opinion. He sent it to the Supreme Court. And what normally happens after that is the Supreme Court, and I'll talk a little bit about this later, but the Supreme Court will issue an order and say, okay, we received the report of the special master. The parties have 30 days to file exceptions to the special master's report. In Montana versus Wyoming, the order said something like, okay, and this is like not really paraphrasing at all. This is like pretty much what it said. They were like, okay, we've received the report of the special master. I want you to think really hard about whether you need to keep using this court as a forum for resolving this dispute. You should, at this point, what appears to be the available damages are like less than the legal fees that you're paying. think really hard about whether you can't just settle this. And if you can't, then exceptions are due within 45 days of this order. And so, you get the sense that, like, the Supreme Court, they often say in cases, it's fine to invoke the jurisdiction of the Supreme Court when you need to, but don't come to us with every little thing that you have. It was quite an extraordinary order in Montana versus Wyoming that sort of like put that out there for the parties to consider. We'll hear your exceptions to this master's report if you really want us to, but we're not going to be happy about it. All right. One issue that I'll just talk about really briefly, because it's something that I've been dealing with for a couple of years in 2 different cases. It didn't come up in Kansas versus Nebraska, but it's the issue of intervention, whether the United States is a required party to the dispute. So sometimes on these interstate rivers, or a lot of times on these interstate rivers, the United States has projects run by the Corps or run by the Bureau of Reclamation, and they're doing various things with the water to comply with federal statutes. They're distributing water pursuant to contracts. They're doing a lot of different things. And so sometimes the question comes up, okay, if the states are having a dispute about the water, can they get complete relief amongst themselves if the United States is not a party that's going to be bound by the judgment? And so this has come up in a couple of different cases where we've had to address it. One is a case that I'll talk about called Texas versus New Mexico. It's a case that's going on in the Supreme Court right now. It's a dispute over the Rio Grande River. And once I explain just a few facts of the case, you'll probably see where the problem is coming from. This is a compact between Colorado, New Mexico, and Texas that divides up the water of the Rio Grande. Colorado, as is common in an interstate compact, is required to deliver water to the New Mexico state line in a certain amount every year. New Mexico's obligation under the compact is to deliver a certain amount of water to Elephant Butte Reservoir, which was a pre-existing Bureau of Reclamation project that's within New Mexico. It's about 100 miles north of the Texas border. And then Texas gets its allocation from contracts that it has with the Bureau of Reclamation. So the problem is that the water, once it reaches Elephant Butte Reservoir, has to travel another 100 miles down to the Texas border before Texas can have its share of the water. And New Mexico has taken the position that the compact does not prohibit it from taking water below Elephant Butte Reservoir. So essentially, New Mexico says, all the compact requires us to do is deliver water to the reservoir. If it never makes its way down to Texas, that's not a violation of the compact. Now, it's not, we have taken Texas's side in this dispute, so New Mexico does have some good arguments for why they can continue to take water below Elephant Butte Reservoir. We think that they're wrong, and we agree with Texas in this dispute. But one of the things, so the Supreme Court asked for our views in Texas versus New Mexico. They said, what do you think about this case? And we said, yes, definitely, Texas should be able to file this complaint. And New Mexico brought up the issue of whether the United States might be a required party, because our project is basically incorporated into the compact. And it's really going to be problematic if the United States isn't bound by the judgment. It's going to, if New Mexico's right, and the Supreme Court says it's right, it's going to affect our federal contracts. And so it would be important in a case like this to have the United States bound by the judgment. Well, we headed off the idea of whether we are a required party or not by just intervening in the case. So we made ourselves a plaintiff. We filed a complaint against Nebraska. The standard for intervention isn't quite the same as it is under Rule 19, which is the Federal Rule of Civil Procedure on required parties. I'll talk about that in just a second. We just have to show that there's federal interests that are at stake that are best presented by the United States. So the standard for intervention by the United States is pretty liberal, but we don't do it very often. We will sometimes do it to protect tribal interests. Sometimes we'll do it if it appears that you would need us to be bound by the judgment and we want to be a part of the case. And in this case, we decided this is important enough to us that we want to become a party. As I said, how the court interprets the compact is going to affect our contracts with water users that receive water from Elephant Butte Reservoir. And also, we have a treaty with Mexico that requires the United States to deliver water from the Rio Grande to the Mexico border. And so, the compact does carve out and say nothing in the compact shall prejudice those rights, but there is a problem if New Mexico is taking too much water when we try to determine how much water we're sending down to Mexico. So the United States intervened, and when we intervene in the case, we become a full party. One bad aspect of that for us is that we then become responsible for a portion of the master's legal fees, or the master's fees. So we're all in when we intervene. We become financially responsible, we're gonna be bound by the judgment, et cetera. One thing that I found really fun, but that you can sort of imagine a room filled with appellate lawyers and Supreme Court lawyers. We made the decision we were going to intervene. We talked to the Solicitor General about it, told him why we wanted to do it, and he said, okay, great, let's intervene in this case. And then we were like, okay, how do we do that? It's not something we do very often, and it's the natural resources lawyers that were there said, well, we'll have to file a complaint. And we were like, file what? What is a complaint? I've never written a complaint before. I'm an appellate lawyer. And so I filed a complaint in the United States Supreme Court, the first time I ever did it. There's lots of examples of complaints being filed in the Supreme Court because the states file them, but the federal government does things a little bit differently sometimes. I mean, we file our briefs with a gray cover. We have a lot of little idiosyncrasies in our office. And so I was trying to find examples of complaints that we'd filed in other original cases. And Ed Needler, who's the deputy that handles the original cases, he said, okay, here's ones that I remember we intervened in. And he listed off all these cases. And when I looked them up in Westlaw, they were from 1967. And I'm like, all right, I guess I'll go try and find the complaint. And we did. Our files are very good. I located them all. But it was definitely a fun experience to write up a complaint. It was, when you get to the end of your brief, and normally if you're an appellate lawyer and if you're a Supreme Court lawyer, the conclusion section just says, this case should be reversed, or this petition should be denied. But when I got to the prayer for relief, I was like, all right, I just get to ask for stuff. I don't know, all right, that's pretty cool. But it was kind of a fun experience, and everybody in the office, I have to say, was a little bit jealous that I got to file a complaint. When I told Ed Needler, who is the deputy that works on original cases, he's worked for the Department of Justice for about 40 years in an appellate function. And when I told him, Ed, I've never filed a complaint before, he said, me neither. So we got to file our first complaint. It was kind of fun. If the United States doesn't intervene, so in Texas versus New Mexico, we headed off that question by just intervening in the case, so the master or the court never had to make a decision about whether we were a required party. But we're not going to intervene in every case, and we, like I said, don't do it very often. So the issue of whether the United States is a required party is actually being teed up right now in a case called Florida versus Georgia that's been filed in the Supreme Court and referred to as special master and is currently in discovery. In this case, basically Florida has sued Georgia for an equitable apportionment of the Apalachicola-Chattahoochee-Flint River Basin, the ACF Basin. It's a river that has never been apportioned. Atlanta sits up on the top portion of the Chattahoochee, and so Florida has become concerned in recent years that with the growth of Atlanta, that Georgia is taking more than its fair share of the water. That remains to be proven. We don't know, but the Supreme Court has allowed the case to go forward, and they're taking a look, and they're doing discovery now. When the Supreme Court asked us if they should take the Florida versus Georgia case, we said, well, this is an important issue, and yes, the court is going to have to divide up this river basin at some point, but we don't think you should do it now because the Corps of Engineers is currently engaged in an administrative process, where we're updating the master manual for all of our projects in this basin, and we would like to complete that before this case goes forward. For legal reasons, for example, if the Corps decides it needs a certain amount of water for hydropower, navigation, flood control, all the different things that it by statute is required to do, then those uses need to be taken into consideration when the court is deciding how much water it has to divide up among the states. And also for practical reasons, because we know that we're going to have requests served on us for document production, and we don't have the resources while we're trying to finish this master manual update. The court didn't do that. The court granted Florida leave to file the complaint, so the case is going forward. And now Georgia has raised the issue of whether the United States is a required party. And we've sort of made clear, the United States, you can't just bring the United States in if they're a required party because of sovereign immunity. A state can't sue the United States. So if we are a required party and we're not going to intervene, the case has to stop. And so this is actually going to be something that the Supreme Court will decide in Florida versus Georgia, whether the United States is a required party and whether, even if we are, the case should nevertheless proceed and maybe be tailored so that it won't affect the possible interests of the United States. One just sort of practical tidbit that I'll share that's sort of interesting about working on original cases. We filed a brief just last week on whether we think we're a required party. We said we think we are because we control the water that goes into Florida. There's a dam and a reservoir right there at the Georgia-Florida border. And it's possible that our interests could be prejudiced because if the equitable apportionment came in the form of saying Florida gets this much water, and under the Corps' interpretation of the federal statutes, we thought we needed more water up in Georgia for federal purposes, then there might be a conflict and we'd have to decide what to do. Congress told us to do these things with it. The Supreme Court tells us we have to deliver this much to Florida. Which one do we follow? And so we said, there are ways that you could let this go forward, including if the relief just comes in the form of a consumption cap in Georgia that doesn't affect what we can do with the water. And so the master is deciding that issue right now. But the point I was going to make is when you're litigating these general issues in the United States Supreme Court, there's a lot of thought that goes into what you say, because if the master now, not that there isn't always, but when the master comes up with a decision on whether the United States is a required party, he can write that up into a report and then the Supreme Court can review it. And so we want to make sure that we're not saying anything about the doctrine of required party that's inconsistent with any positions we take in district court, because we have to be prepared for a Supreme Court decision on the Rule 19 standards for being a required party that may be used as guides in federal district courts. One other way that this has come up, we haven't filed anything on this yet, but the parties just last week served the United States with a lot of discovery requests in the form of subpoenas and also under the general TUI regulations for each agency, which is how you typically get information from a federal agency. And when the United States is served with subpoenas and things like that, there's a lot of arguments that we make in district courts. Some of them are excellent arguments about why we shouldn't have to produce documents. Some of them are less excellent, but still reasonable. And so we make them sometimes in the district courts because you never know what's going to stick, and it doesn't matter if a district court rejects your argument. If the district court rejects your argument and you want to appeal it to the Court of Appeals, you have to ask the Solicitor General for permission, and so my office will take a look at it and we'll say, we don't know, this argument is not reasonable, and we don't want a Court of Appeals case rejecting it. It could be bad for other areas of law. Usually though, the standard is just, is the argument reasonable? And so a lot of times we're making arguments on behalf of the United States that are reasonable, but not awesome. But in the Supreme Court, you have to be very careful of that, because when we respond to these subpoenas, there's a plethora of arguments that we might make in district courts about why we shouldn't have to produce documents or why we shouldn't have to do it in the time frame provided by the master, et cetera. But if those arguments are weak, and if we've been having some success with them in the district courts, we have to be prepared for a Supreme Court opinion rejecting them, and then we can't make them anymore anywhere. So it's just a little practical tidbit that we have to consider when we're litigating original cases. All right. The next thing that happens, and I've referenced this a little bit, When the Supreme Court takes the case, it typically will the Supreme Court doesn't call witnesses itself and hear testimony. I think it maybe used to, like back in the day. But they typically will appoint a special master who litigates the case, or he presides over the case like a district court. He hears evidence. He has people testify. They do depositions. There's all kinds of discovery and things that you would do in a district court. And then periodically, when he reaches a point where there's something that the Supreme Court should take a look at before we go forward, the master will summarize his rulings in a report to the Supreme Court. And the Supreme Court then permits the parties to file exceptions. It's sort of like you would do, I guess, if a magistrate judge issued a report and then you were going to take exceptions and get a de novo review by a district court judge. You can do the same thing when the Supreme Court assigns your case to a special master. You can file exceptions to the master's opinion, and then the Supreme Court will hear them and conduct a de novo review, which, I'll talk about this in a little bit, but it is de novo review, I think not just in name only, but the special master has been looking at the case for a long, long time. I think in practice there's a bit of deference given to what the special master's done, even if in theory it's a de novo review by the Supreme Court. The Supreme Court will hear arguments on the exceptions, so that's kind of a cool thing when, the Supreme Court is obviously mostly just an appellate court, but once in a while you'll see these original cases pop up on the docket, and the Supreme Court is hearing exceptions to the special master's report. I think we found in Kansas versus Nebraska, the court was very engaged in the argument in the original case. They were very interested in what was going on. I think they felt a special responsibility personally to, make sure that they were doing right between the states and that they were understanding the issues that the special master had worked on, because this is the only shot that the parties have. The U.S. typically files a brief in these original cases when they get back to the Supreme Court. Sometimes the United States participates a lot in the special master proceedings. Sometimes we don't. It just depends on what our interests are in that litigation. Sometimes we'll provide documents and testimony, but we won't really participate if we haven't intervened. And then when it gets back up to the Supreme Court, especially if they've asked us to participate in the case at an earlier stage, we usually will file a brief telling them what we think about it, because we would never want them to get angry if we didn't. Before I get to Kansas versus Nebraska, I'll just have one slide on the general principles that the court uses in compact interpretation. There's two of them. There's probably more, but these are the two that you see at the beginning of every brief on the merits in a compact case. An interstate compact is a contract that must be construed and applied in accordance with its terms. And the Supreme Court has also said that an interstate compact is a law of the United States, and it therefore must be interpreted as a federal statute. So those are not always totally compatible with each other, and they're also not absolute principles. Sometimes even though a compact is to be treated like a federal statute, there's some principles of statutory interpretation that don't make sense in the context of an interstate compact. One example of that is a presumption against preemption, and that's something that came up in the Tarrant case between Texas and Oklahoma that I was talking about. The presumption against the preemption of state law is a presumption that's based on the idea that Congress wouldn't cavalierly preempt state law unless it really meant to, or it said it was doing that. And one thing the Supreme Court said in Tarrant was that that principle doesn't really apply in interstate compacts. If you can't say, okay, the state law is not preempted by the compact because of the presumption against preemption, because the court said this is more of an arm's length transaction between two sovereigns. You need to tell us what you want to do about state law. We're not going to make any presumptions about it. And although the Supreme Court says that the compacts are like a contract, there are some aspects of general contract law that are not incorporated into Supreme Court doctrine. For example, the implied duty of good faith and fair dealing, which is part of contract law, it's in the restatement of contracts. The Supreme Court has rejected that as a principle of interstate compacts, saying, again along the same principles, these are two sovereign states that negotiated an agreement with one another. These squishy equitable principles, when it comes to interpreting the compact, there's not much room for them. But in general, the court uses those two principles as a guide, and that's often how you shape what your arguments are going to be. I'll talk a little bit about our favorite case, Kansas versus Nebraska. There are two main issues in this case, and I assume everybody here is probably familiar with it, but I'll just give a 2-minute synopsis for people that aren't. This is a case where Kansas sued Nebraska for violations of the Republican River Compact for taking more than Nebraska's share of the water of the Republican River Basin. The parties had reached a settlement agreement in 2003 after they litigated in front of the Supreme Court whether groundwater pumping that affects surface flow counts as consumption of water under the compact, and the Supreme Court said, yes, it did. And so the parties got together and they created some accounting procedures and a groundwater model that determined how groundwater pumping in each state was affecting the flow of the Republican River. And then they created a new compliance mechanism that was based on 5 years. So if Nebraska went over its consumption amount in the first year, it doesn't really matter as long as you are underneath the average at the end of the 5-year period. So it's okay to go over as long as you make it up in the coming 5 years, and it continuously resets. So I don't know, when I was working on this case, I had a little trouble understanding all of that at first since I don't really do this, but does anybody have a Fitbit like I do? No Fitbits in here? All right, so the Fitbit, it counts your 7-day steps. This is how I was explaining it to myself. On the 7th day, it subtracts your steps from the 7th day that's already passed, and so you're seeing a total of the last 7 days of all the steps you've had. And so that's the way that this sort of works, that you're always knocking off the 5th year ago. But in dry years, they use a different 2-year accounting mechanism. So there's certain triggers under the accounting procedures where if there's certain dry conditions, then we're going to check every 2 years, and the standards we're going to use are going to be different. And so Nebraska, when it first came time to check in at the end of a 2-year dry period, was over its consumption limit, and it wasn't able to make it up. And so Nebraska violated the compact. Nebraska admitted it violated the compact. It took too much water. The states basically agreed by the end of the original case what amount that was. And so the question was, what damages does Kansas get? When we were looking at this question, basically the court's jurisdiction is equitable in nature, and we're going to look at contract principles, but we're also going to consider that the court is just trying to do what it thinks is fair in an original case. And you may recall, if you took contracts class, that typically the damages you get when somebody breaches a contract is expectation damages. You get the amount of your loss from the breach. There's a separate principle of discouragement. It's a principle of unjust enrichment. There's a whole separate restatement of unjust enrichment about it, where if somebody breaches the compact and they gain from that breach more than you lost, then in some circumstances, you can get the amount of their gain. And so we were trying to figure out what was the appropriate way to assess damages in this case. And the special master heard a lot of evidence on this. And he concluded that Kansas's actual damages were about $3.7 million. And he never quantified what Nebraska's gain was, but he said the water was substantially more useful and worth more on farm upstream in Nebraska. So it's likely that Nebraska gained many multiples of $3.7 million by breaching the compact. So the question becomes, is it really the best way for us to handle the situation to just give Kansas the $3.7 million that it's out, or should we add a little something onto that and discourage some of the profit that Nebraska got from breaching the compact in order to stabilize this agreement? Because you could imagine if the only thing that Nebraska had to do when it breached the compact was to send down the money that Kansas lost, there's way too much incentive to breach the compact, because if you're getting, I'm just making this number up, but let's say $10 million of a benefit from breaching, and you only have to send $3.5 million to Kansas, why wouldn't we just breach the compact? And there's in law and economics, the concept of an efficient breach is not necessarily a bad thing. There's limited water. If we're getting more use out of it upstream, there's arguments to be made that that's the best way to deal with it. But where we came down and where the Supreme Court came down was that in a situation like this where you have two sovereigns that have divided up the water, it's not acceptable to have an efficient breach of the compact. And so, yes, we want to have some amount of discouragement to make sure that the compact becomes stabilized and that we don't have the upstream states continuing to breach the compact because they know they're only going to have to send expectation damages downstream. The question then becomes how to fit that into the existing bodies of contract law, because typically, and you'll see this in the restatements, you have to have a deliberate breach in order for discouragement to be justified. And here the master went out of his way to say that Nebraska's breach was not deliberate. It was basically where we came down was he said it was reckless. He said Nebraska knowingly exposed Kansas to a substantial risk that it was going to violate the compact because the plan that it came up with after the settlement agreement in 2003 was, it didn't take effect for like a year and a half. The reductions in groundwater pumping were not enough to bring Nebraska into compliance. And even though Nebraska worked very hard in 2006 and afterward, and I know is working very hard right now, in that initial period just wasn't doing enough and could see that it wasn't doing enough and that it wasn't going to meet its obligations under the compact. And so we have like a knowing breach of the compact that's not deliberate. Where the master came out was he said, look, it is important to stabilize this compact, and so I'm going to award an extra $1.8 million of damages. And it was, again, not something that fits perfectly into contract law, because typically there's a choice between expectation damages and discouragement. So what the master came up with was like full expectation damages and a little bit of discouragement. But the Supreme Court concluded that that kind of works. Discouragement is warranted if it's needed to stabilize a compact and deter future breaches, but that if partial discouragement will serve to stabilize the compact by conveying a message that future breaches wouldn't be tolerated, then the court has discretion to order only that much. And what the court said in Kansas versus Nebraska was, we think $1.8 million is sufficient to account for the fact that there was a knowing breach, essentially, even though it wasn't deliberate. But since we see all these great plans that you have in place going into the future, we're not going to impose the full amount, and we're not going to do something that's so terrible or onerous because we can see that you're trying to come into compliance. The other issue, and I'm so glad that since I guess we started a little late, I actually have some time left to cover this, is reformation. And those who were at the argument in Kansas versus Nebraska know I had 10 minutes of time in that argument, and we supported Kansas on the discouragement issue, and then we supported Nebraska on this reformation issue. And as a result, we supported neither party, and we got 5 minutes from Kansas and 5 minutes from Nebraska. But I started at the argument with discouragement, and the Supreme Court never let me get off of that topic. And when I knew that I was reaching the end of my argument, I said, look, I've taken time from both parties. Could I please talk about the reformation issue for a few minutes? And then my red light went on, and I was like, So my apologies again to the folks from Nebraska. That is not how I intended the argument to go, but as you know, you can't really control it. So here's what I would have said about reformation, and we said it in our brief, and the Supreme Court agreed with Nebraska on this issue, so it is not really that big a deal, and especially in Justice Thomas's eyes. The basic issue on the accounting procedures, or the reformation, in this groundwater model that the parties came up with, they had these accounting procedures that measured a lot of different things, and the main thing they were trying to measure was the effect of groundwater pumping on the surface flow in the basin so that you could figure out how much water each state was using. One of the other things that the groundwater model did was it found a way to measure imported water because Nebraska imports some water into this basin from the Platte River. And so there was a separate little switch that you could turn on to measure how much imported water was coming in. Well, the parties used these accounting procedures in this groundwater model, and then Nebraska figured out later that when we were calculating the decline in surface flow from groundwater pumping, we left the imported water switch on when we were doing that calculation in the procedures. It really should have been turned off because there becomes a point when the stream runs dry and groundwater pumping is not affecting the surface flow. And in those conditions, you shouldn't be charged for consuming the surface flow of the water because you're not. But if you leave the imported water switch on, you continue to be charged for pumping groundwater when it's only imported water that's being taken out of the stream. You may have already understood that, and it took me a long time to understand that, and you may not understand that at all. The point is, Nebraska wanted to change something that was in a settlement agreement that had been approved by the Supreme Court. And the way that the settlement agreement says you have to change it is that all the states have to agree. And because this mistake essentially was to Kansas's benefit, Kansas would not agree to the change. And so Nebraska, after taking it to arbitration, filed a counterclaim in the original case asking to modify the accounting procedures to basically shut off the imported water switch before the groundwater calculations were done. This one was a little bit of a puzzler, and I think the master was a little puzzled by it too, because you think one way that you could do it is to just get rid of that part of the accounting procedures or like sever it. The settlement agreement had a non-severability clause in it, which is why we sort of concluded when we were looking at it why the master didn't go down that route, because we didn't want to get rid of the whole settlement agreement. So he sort of on his own came up with what we ultimately concluded was a pretty creative way to do it, which was he took the contract principle of reformation and said, you know, reformation is warranted if that there's a mistake in the agreement, a mutual mistake, so that the agreement doesn't reflect the parties' true intent. And, you know, we said in the settlement agreement, imported water is not going to count toward the state's consumption of the water of the Republican River Basin. The compact itself says it's only dividing up the water of the Republican River Basin and not other water. And if you're letting the imported water count towards Nebraska's consumption, you're actually changing the allocations that are made under the compact that's been approved by Congress, because Nebraska is getting less Republican River water than it should be. And we sort of went back and forth about this. I mean, you could see why you wouldn't want just any time there was a settlement agreement and the parties looked at it and said, there was a better way we could have done this. Let's go back to the Supreme Court and reform it. We wouldn't want that happening all the time because we want states to settle these cases. The Supreme Court wants states to settle these cases. And if it starts to look like settlement agreements can be revisited by the Supreme Court, that wouldn't be a good thing. But we ultimately concluded, and the Supreme Court ultimately concluded, that the mistake here was pretty clear. And there was no other way that we could fix it, because Kansas wouldn't agree to it and the states have to be unanimous. And that we would support Nebraska's counterclaim basically because even though it was not a huge amount of water in any given year, if we didn't change it, Nebraska was going to be shorted, 7 to 10,000 acre feet of water every year going forward. And that obviously adds up to a lot. So what the Supreme Court said in its opinion, it agreed with Nebraska and with the United States that the court's equitable authority encompasses modifying a technical agreement to correct material errors in the way it operates and align it with the compacting state's intent. And it said the case for modification was stronger here because the mistake actually made the accounting procedures inconsistent with the compact that the states had agreed to and that Congress had approved. So that's Kansas versus Nebraska. I'm so happy I was finally able to talk about the accounting procedures issue, even if the Supreme Court didn't let me. So those are the basics of how the Supreme Court hears cases in its original jurisdiction and how the United States becomes involved. I hope it was informative and that I wasn't just telling you things you didn't already know, but I think we started a few minutes late, but if anybody has questions, I am happy to take some questions.
Do you have a mic?
There's one here.
In other words, I thought Kansas wanted a water master to run the Republican River. Did
Yes.
that come up in the case, and what was the U.S. position?
We never ended up taking a position on the water master. So yes, Kansas. Kansas probably has more experience than I do writing a complaint. But when they got to the end of their complaint and asked for various relief that they wanted, in addition to damages, and an injunction, which the Supreme Court denied, and which was also an issue in this case, it was kind of a more minor issue, so I didn't talk about it here. But they also asked for a river master, yes, to essentially oversee what was going on in the Republican River Basin. That is a pretty extraordinary relief for the Supreme Court to grant, and the special master denied that relief. And Kansas did not take an exception on that to the Supreme Court, so it wasn't a part of the Supreme Court case. You'll periodically see when the Supreme Court issues its orders, there's a few rivers, and I don't know which ones they are, that have river masters, and they get fees when they do things. And so periodically the Supreme Court's orders list will have approved fees for a river master somewhere who's overseeing people's actions in a compact case.
You mentioned earlier in your talk about the keeping possible federal assets or whatever separate and maybe not being a divisible part of like a compact. Did that weigh into this in any way?
Not in Kansas versus Nebraska. I think because there was already a compact that was negotiated between the states, and when the compact was negotiated, I think federal interests were already taken into account. It's not something that came up in this case. It'll come up in a case where we have a river that hasn't yet been apportioned, and only because of the growth of a city on the river are people starting to become concerned about it. And so in those cases, we want to make sure that, and in some of those cases, the Corps or the Bureau of Reclamation will already know what the interests of the United States are and what we think are the requirements of Congress for the projects that have been authorized and paid for by the United States, or sometimes they're repaid. But in this case, it came up because the Corps of Engineers has been trying to redo the water manual for like decades. I think it's using a water manual from like decades ago, but it hasn't been able to do the update process because of litigation in that water basin. And so the federal responsibilities in that basin are not clearly defined, which I think is kind of an unusual situation.
You mentioned as your prior experience having clerked for a couple of the justices, when the oral arguments are completed and the briefs are all in, they all go behind the curtain. Can you talk to us a little bit about what happens at that point?
Sure. Every Friday, the Supreme Court has a conference. And so they hear cases Monday, Tuesday, Wednesday, 2 weeks a month, and not every month, only October through April. Every Friday they have a conference where they sit down at a conference table, and they literally go around the table and say how they're going to vote in that case. And so the chief will start out and he'll say, okay, Kansas versus Nebraska, here's what I think, and then they'll go around in seniority order and say what they think. And then once they determine what the vote is, the Chief Justice will assign the opinion to somebody if he's in the majority. And so in this case, he was not in the majority. I guess he was on one issue, so I don't really know. It probably was assigned by somebody else. But whoever's the senior justice in the majority will assign the opinion. Somebody assigned it to Justice Kagan, and then she starts to write an opinion. And there are times when, after that preliminary vote, somebody might change their mind. And so something that was a 6-3 opinion, especially at the end of the term, you see this happening. It looks like a very contentious case at the argument, but it was argued in April, and they only have 2 months for the opinion, and so it ends up being 9-0, and you're like, I wonder if they all agreed on it, or if they just ran out of time to write a dissent or something like that. But sometimes an opinion will come around, and a justice will say, I actually am going to change my vote because I was persuaded by this, or something like that. I don't know if that happened in this case. It was 6-3 on the discouragement issue, and then 5-4 on the reformation issue. And the Chief Justice, who was with Kansas on both, actually, he wrote a very short opinion that just said, I agree, discouragement is okay. I disagree that we can reform the settlement agreement. So I don't really know if anybody changed their vote or what happened, but that's how they typically do it.
And one question that I frequently get that I'm never able to answer is how is a special master selected? Can you shed any light on that?
Oh, so I actually don't know if what I'm about to say is true or not, but I will tell you how I think they are selected. I think it's the case that whoever's the circuit justice for the circuit where the dispute is happening gets to pick the special master or recommend a special master to his colleagues. And if it's a dispute that spans 2 circuits, then we think the most senior person is the one who's selected. But yeah, there's a lot of special masters that come from this particular law firm in Maine, which is great. They have a lot of experience, and they oftentimes have worked as an assistant to a different special master before they do it. In Texas versus New Mexico, we have a special master in New Orleans who is not a water expert, not a water lawyer. We think he probably is somebody that Justice Scalia thought would be a great special master. And the special masters are, they're lawyers. They're people that are just presiding over the case as if they're a district court judge. My contracts professor in law school, Professor Maggs at George Washington University, was a special master in a couple of cases. And I remember him saying that when he first got a call from Justice Thomas asking him to be a special master, he was like, I don't know how to do that. And he said, I don't really know, I'm a contracts professor, I don't really know anything about water law. And they said, that's fine. We want somebody who's just going to be a fair judge and who's basically just going to act like a district court judge, because if you were filing this thing in a federal district court, you wouldn't get a water expert presiding over it. You want somebody who's just going to be able to take a look at the case and make fair decisions. So that is my opinion on how special masters are selected. I don't know if it's fact.
I just had one question. When I walked away from the Kansas v. Nebraska opinion, I said, well, the court's really willing to do a lot of equity in compact disputes now. Did the department have, or did your office have any position on whether that was a good thing or a bad thing? Was that sort of the principle that you were trying to get established in this case? Or more broadly, do you think it has an impact on negotiations and compact disputes and things along those lines?
It is definitely something, and in our brief in this case, we sort of suggested, and I think it was probably clear from what I was saying about the damages issue in particular, yeah, both of the issues in that case didn't really fit perfectly into like straight up contract law. But when we thought about how we thought the case should come out and what the damages should be and whether the compact should be reformed, there's just something that made sense about what the special master was doing, and we think it's fine. And we argued a lot in our brief for there to be some flexibility in what the Supreme Court does when it's deciding these disputes and trying to come up with fair decisions between the parties. It's not just going to apply straight up contract law all the time, because these are special situations where it's 2 sovereign states that have come to an agreement, and you're trying to figure out what should happen when somebody violates the agreement or when there's a mistake in the agreement or something like that. And I think it's a good thing that the Supreme Court has a little more flexibility. As far as now, the dissenting justices in Kansas versus Nebraska said that's crazy, that there's too much squishiness now. And I think it'll remain to be seen how it comes into play in terms of negotiating compacts or coming to agreements. Courts, the states may be a little more careful or more precise about things they say, and they may want to create specific damages provisions and things like that, so that those would just be enforced by the court instead of the court using what it thinks is fair to come up with damages. But in general, when it's something that's not covered by the compact, I don't think it's a bad thing to have some room for the Supreme Court to decide what's fair.